možemo ugostiti naše drage kolege, suradnike s projekta Sveučilišta u Grazu, kao i njihove pozvane izlagače koji će danas govoriti o raznim aspektima europskog naloga, platnog naloga i europskog postupka za male sporove. U tom smislu, evo, veselje nam je pozdraviti i sutkinju Martinu Arnec sa suda u Beču i odvjetnicu doktoricu Škof iz odvjetničkog društva Grlić Vuk Škof. Također nam je zadovoljstvo pozdraviti i profesora Filipa Anzenbergera sa Sveučilišta u Grazu te magistricu Evu Wolkenhofer sa Sveučilišta u Grazu također. Nadam se da ćete s nama se družiti do kraja današnjeg dana i potom sutra, kada smo za vas pripremili zanimljiva izlaganja, prvenstveno s naglaskom na praktične aspekte ovih postupaka koji su uređeni na razini Europske unije i vjerujemo da ćete, kao što je dio vas već bio s nama na proteklim seminarima, biti vrlo zadovoljni, a također i uključiti se u diskusiju, postavljati pitanje i davati komentare, budući da je to nešto što doista pokušavamo i ohrabriti na ovakvim seminarima. Nadamo se da ćemo svi zajedno zapravo dobiti dodatnu vrijednost kroz ovaj seminar u vidu iskustava, razmjene iskustava i razmjene znanja o ovim postupcima. Da dalje ne duljim s uvodom, evo, drago mi je što sam vas mogla pozdraviti u ime organizatora. Ja bih sada riječ prepustila našim govornicima koji će se onda nakon ove uvodne najave obratiti vama i predstaviti kako biste mogli vidjeti zapravo čime se oni bave i odakle zapravo potječu njihove kompetencije da govore na ovom seminaru.
Is it okay now?
Yes, we'll just here.
Okay, thank you for this introduction. My name is Eva Wolkersdorfer. I am a project assistant at the University of Graz. And today I will give you a theoretical overview about the European small claims procedure. If you have any questions, please ask. You can interrupt me anytime. And yes, I would suggest that we start. So the European small claims procedure was established in 2009 in all member states except for Denmark. And before that, many member states had introduced national simplified civil law procedures for small claims. But these procedures were too different to be applicable in cross-border cases. So therefore, it was necessary to establish a European procedure for small claims. Don't know if it, oh yeah, yes. The main source of law at European level is the regulation number 861/2007. And what is not expressly regulated in there is determined in accordance with national law. What were the legislators' aims in introducing this procedure? So according to the recitals, the aim of the European legislator was to introduce an efficient and uniform instrument to simplify and speed up litigation concerning small claims in cross-border cases. The European small claims procedure also should facilitate access to justice and reduce costs by offering an optional tool in addition to the possibilities existing under the laws of the member states. The small claims procedure should also make it easier to obtain recognition and enforcement of a judgment given in a European small claims procedure in another member state. Then the European Small Claims Procedure seeks to promote fundamental rights and takes into account, in particular, the principles recognized by the Charter of Fundamental Rights of the European Union. And according to the recitals, the court should respect the right to a fair trial and the principle of an adversarial process. So the aims of the European legislator to simplify and to speed up litigation, to reduce costs, and to eliminate the intermediate proceedings necessary to enable recognition and enforcement can also be found in Article 1 European Small Claims Procedure, where the subject matter is regulated. So what are the characteristics of the procedure? It is an optional instrument and offers the litigant only an alternative to the domestic and European procedures. So the claimant can choose whether to initiate proceedings under the European Small Claims Procedure or other European or domestic procedures. So the European Small Claims Procedure is an additional and optional instrument. In order to facilitate recognition and enforcement, a judgment given in a member state in the European Small Claims Procedure should be recognized and enforceable in another member state without any declaration of enforceability and without any possibility of opposing its recognition. Then it is a very simple way of initiating proceedings by filling in and sending standardized forms. There's no requirement to be represented by a lawyer. The taking of evidence takes place without any formal restrictions, and it is a very swift proceeding due to clear time limits. The material scope of application can be found in Article 2 European Small Claims Procedure. So according to this article, the European Small Claims Procedure shall apply in cross-border cases, as defined in Article 3, we will talk about this later, to civil and commercial matters, whatever the nature of the court or tribunal, where the value of the claim does not exceed 5,000 euros at the time when the claim form is received by the court or tribunal with jurisdiction, excluding all interest, expenses, and disbursements. And it shall not extend in particular to revenue, customs, or administrative matters, or to the liability of the state for acts and omissions in the exercise of state authority. So this was the definition of the scope of application, and I will now go into more detail about the requirements of the scope of application. So the first requirement is a case in civil and commercial matters, and according to the European Court of Justice, the term civil and commercial matters is to be interpreted autonomously, and it is the sum of all private law disputes. The ECJ held that two elements are relevant for deciding whether or not a dispute is of a civil or commercial nature. On the one hand, it is the subject matter of the dispute, and on the other hand, it is the nature of relationship between the parties involved. So in principle, a matter is not civil or commercial when it concerns a dispute between a public authority and a private person, and the public authority acts in the exercise.
Čekaj, ali ja se ne čujem, jo? A kak znaš?
Okay.
Okay, ajde.
Okay, thank you. So,
ajde, s tim kavom drugim put, bok.
So the fact that the public authority is involved in the proceedings does not necessarily mean that the European Small Claims Procedure is not applicable. So the decisive factor is if the tasks and powers of the public authority are functionally different from those of the private parties. So proceedings in which a public authority and a private person are opposed to each other may fall under the scope of application of the European Small Claims Procedure if the public authority, for example, has entered into contracts with the private person at the level of equality and not in the exercise of state authority. Then in Article 2, Paragraph 2, European Small Claims Procedure, you can find a definitive list of specified exclusions. So the European Small Claims Procedure shall not apply to matters concerning the status or legal capacity of natural persons, rights and property arising out of a matrimonial relationship, maintenance obligation arising from a family relationship, parentage, marriage, or affinity, wills and succession, including maintenance obligations arising by reason of death, bankruptcy, proceedings relating to the winding up of insolvent companies or other legal persons, judicial arrangements, social security, arbitration, employment law, tenancies of immovable property, or violations of privacy and rights relating to personality, including defamation. So all these exceptions in Article 2, Paragraph 2 European Small Claims Procedure are regarded as particularly important by most of the member states. So in these cases, a simplified procedure may not be justified. In most member states, special courts have been established for these matters, which apply special national provisions and whose scope is not to be restricted. In contrast to the European Order for Payment procedure, the enforcement of claims arising from non-contractual obligation is possible in the European Small Claims procedure. So, for example, claims arising from traffic accidents abroad. We will talk about this later this afternoon. So which types of claims are admissible? The text of the regulation does not contain any restriction to a certain type of claim, and contrary to the European Order for Payment procedure, the scope of application is not limited to monetary claims. So actions for performance are covered by the scope of application, irrespective of whether or not they are for a monetary payment or not. And according to the prevailing view, also actions for a declaratory judgment and actions requesting a change of a legal right or status are covered by the scope of application. Yeah, what about the value of the claim? So in its original version, the European Small Claims Procedure only applied to cases where the value of the claim does not exceed 2,000 euros. And at first, a uniform limit of the value of the claim was quite controversial, and there were intense discussions in the European Commission about this. So the main argument against a uniform limit of the value of the claim was that the purchasing power of the same sum is different in different member states. Also, a distinction between natural persons and legal persons was proposed but immediately rejected. So a compromise solution had to be found. And the legislator took into account that a limit that is too low does not have sufficient practical significance. If too high, the simplification of the procedure could not be justified. So initially, a limit of 2,000 euros was introduced. Since the small claims procedure had a little practical significance in its first years of its application, the legislator tried to make it more attractive by raising the value of the claim from 2,000 euros to 5,000 euros with the entry into force on the 14th of July in 2017. So the new version of the small claims procedure applies to dispute of an amount up to 5,000 euros. And according to the recitals, increasing this value would improve access to an effective and cost-efficient remedy for cross-border cases, in particular for small and medium-sized enterprises. So increased access to justice would enhance trust in cross-border transactions and would contribute to the fullest use of the opportunities afforded by the internal market. The relevant point in time for the examination of whether the value of the claim exceeds 5,000 euros is the receipt of the claim by the competent court. A later extension to more than 5,000 euros has the effect that the European Small Claims Procedure cannot be continued because the scope of application is not opened or in this case. However, if, for example, the value of the claim is subject to exchange rate fluctuations and the value of the claim later increases to more than 5,000 euros, in this case, the European Small Claims Procedure remains admissible. How to calculate the value of the claim? So the value of the claim must be calculated excluding interest, expenses, and disbursement. at the time of receipt of the claim, according to Article 2, paragraph 1, European Small Claims Procedure. So interest, expenses, and disbursements are only to be taken into account if they are claimed independently as a main claim. The limit of the value of the claim may not be changed by the parties, so any agreement to the contrary shall be null and void, and all further questions regarding the calculation of the value of the claim are governed in accordance with national law according to Article 19 European Small Claims Procedure. What effect of a counterclaim of the defendant have on the value of the claim? So the term counterclaim means an action brought by the defendant in the same proceedings against the claimant. So the counterclaim is independent of the claimant's action and aims to enforce an independent claim of its own. The main rule is that the value of the claim is not to be added to the value of the counterclaim. So the claim and the counterclaim are separate claims for the purpose of their valuation. But if the counterclaim exceeds the limit of 5,000 euros, then the claim and the counterclaim shall not proceed in the European Small Claims Procedure, and the proceedings shall be continued in accordance with national law. And you can find this in Article 5, paragraph 7, European Small Claims Procedure. The text of the regulation does not take into account the assertion of a claim in a currency other than the euro. But in field 7 of Form A, there's the possibility to select all other currencies available in the member state. So the assertion of a claim is also possible in a currency other than the euro. Another requirement of the scope of application is a cross-border case, and in Article 3, paragraph 1, European Small Claims Procedure, you can find a legal definition for that. So a cross-border case is one in which at least one of the parties is domiciled or habitually resident in a member state other than the member state of the court or tribunal seized. So the term domicile shall be determined in accordance with Article 62 and 63 Process 1A regulation. So Article 62 Process 1A regulation refers to the domicile for natural persons and does not give an autonomous definition for that. So according to Article 62 Process 1A regulation, in order to determine whether a person is domiciled in a member state, the court shall apply its internal law. Article 63 Process 1A regulation gives an autonomous definition of domicile for legal persons. So according to Article 63, a legal person is domiciled at the place where it has its statutory seat, central administration, or principal place of business. The term habitual residence is also not defined in the European Small Claims Procedure, but according to the Hague Maintenance Convention, it is the center of the person's ties or where the center of his or her existence has been for at least 6 months. So here you can see some examples for cross-border cases. So the claimant with domicile or habitual residence in a member state seizes the court of another member state. The claimant with domicile or habitual resident in the state of the court brings a claim against the defendant with domicile or habitual residence in another member state, or both parties are domiciled or habitually resident in the same member state, but the court of another member state is seized, or the claimant with domicile or habitual resident in a third country brings a claim in a member state, and the defendant is domiciled or habitually resident in another member state. On the other hand, the regulation does not apply if the domicile or habitual residence of all parties to the proceedings is located in the state of the court, or the domicile or habitual residence of one party is in the state of the court of other party in a third country, and this is easy, the domicile or habitual residence, none of the parties is located in a member state. So what are the consequences of the non-existence of a cross-border case? So first of all, the court shall inform the claimant that the claim does not fall within the scope of application of the regulation. then the claimant may withdraw the claim. If he fails to do so, the court shall conduct the proceedings in accordance with national procedural law. And the relevant moment for determining whether a case is a cross-border case is the date on which the claim form is received by the court with jurisdiction. Then, according to recital 26, the European small claims procedure is applicable in all member states with the exception of Denmark. And in Article 29, European small claims procedure, you can find the temporal scope of application. So the regulation shall apply from the 1st of January 2009 with one exception. The regulation does not contain any explicit rule regarding the jurisdiction of the court, but the standard form A indicates in point 4 that the court must also have jurisdiction under the Brussels 1A regulation. So here you can see point 4 of standard form A, and jurisdiction is governed by the Brussels 1A regulation. So this regulation stipulates which courts in which member states have jurisdiction over disputes in civil and commercial matters with an international element. So here you can see the jurisdiction system of the Brussels 1A regulation, and Article 4 Brussels 1A regulation regulates the general jurisdiction. It is the domicile of the defendant. So persons domiciled in a member state shall be sued in the courts of that member state. The nationality is not relevant, and Article 4 regulates only international jurisdiction. So a territorial jurisdiction is determined in accordance with national law. Then in Articles 7 to 9 Brussels 1A regulation, you can find rules on special jurisdiction. The jurisdiction of the place of performance in Article 7, paragraph 1 Brussels 1A regulation is the most important, a special jurisdiction in practice. So if the subject matter of the proceedings is a contract, the defendant can also be sued at the place of performance. And this is usually chosen when the claimant can bring a claim in the member state where he is domiciled. The second most important special jurisdiction can be found in Article 7, paragraph 2, Brussels 1A regulation, conferring jurisdiction in matters of tort, delict, or quasi-delict on the courts of the place where the harmful event occurred or may occur. Articles 7 to 9 Brussels 1A regulation regulate international and territorial jurisdiction, and the claimant can generally choose between general jurisdiction in Article 4 Brussels 1A regulation and special jurisdiction in Articles 7 to 9 Brussels 1A regulation. Then there are special rules for jurisdiction in matters relating to insurance, over consumer contracts, over individual contracts of employment. Then there's also the possibility for a prorogation of jurisdiction according to Articles 25 to 26 Brussels 1A regulation. So the parties can choose the jurisdiction under certain conditions. And in Article 24 Brussels 1A regulation, you can find rules on exclusive jurisdiction. So, for example, in proceedings which have as their object rights in rem in immovable property or tenancies of immovable property. In these cases, the courts of the member state in which the property is situated have jurisdiction. Article 24 cannot be overridden by a prorogation of jurisdiction or by the defendant's voluntary submission on the forum. And Article 24 applies regardless of the domicile and nationality of the parties. And it regulates only international jurisdiction. So territorial jurisdiction is governed by the domestic law of the member states. So how to select the competent court based on the cause of action and the value of the claim. It must be determined whether the European small claims procedure can take place at all or if an exception applies. If the European small claims procedure can be applied, one has to refer to the Brussels 1A regulation to determine which court in which member state have jurisdiction. If there are several courts in the same member state, the court must be chosen according to the rules of territorial jurisdiction, and international and territorial jurisdiction must exist simultaneously for the small claims procedure. How to commence the procedure. So according to Article 4, Paragraph 1, European Small Claims Procedure, the claimant shall commence the European Small Claims Procedure by filling in standard Form A and lodging it with the court with jurisdiction directly by post or by any other means of communication acceptable to the member state in which the procedure is commenced, for example, fax or email. The claim shall include a description of evidence supporting the claim and be accompanied where appropriate by any relevant supporting documents. The use of the claim form is obligatory for the claimant and can be found online and is available in all official languages of the European Union. So here you can see a link for the small claims forms in English. And the obligatory content of the claim can therefore basically only be found in claim form A itself. So in this form, the claimant is requested to provide all the information that is also required for a claim under national procedural law. And the following information is required. So for example, information about the court or tribunal, so the name, the address, and the country. Then the claimant's details and, if applicable, his representative. Also the defendant's details and his representative. Then information about the jurisdiction. So, for example, the domicile of the defendant, the domicile of the consumer, the place of the harmful event. Then the cross-border nature of the case. Then in field 7 and 8, details of the claim. So here you have to give reasons for your claim, for example, what happened, where, and when. And in point 9, there's also the possibility to request an oral hearing. The claim must be examined by the court within 14 days of receipt, but exceeding this period will not be sanctioned. Then the court has to examine the temporal, material, and the territorial scope of application. Then if international jurisdiction exists, if the claim is clear and complete, and if the claim is not manifestly unfounded or inadmissible. Where a claim is outside the scope of application of the European Small Claims Procedure, the court shall inform the claimant according to Article 4, Paragraph 3 European Small Claims Procedure. For example, if the value of the claim exceeds the value limit of 5,000 euros, or for example, if there's no cross-border case. So in these cases, the claimant is given the opportunity to withdraw his claim. If he does so, the proceedings end, but he can file a claim again, for example, under national law. If the claimant does not withdraw the claim, the proceedings will continue in accordance with the rules of national procedural law. If the claim appears to be clearly unfounded or inadmissible, or if the claimant fails to complete or to rectify the claim form within the time limit specified by the court, in these cases, the application shall be dismissed. The terms clearly unfounded and inadmissible are to be interpreted according to national law. And according to Article 4, Paragraph 4 European Small Claims Procedure, the court shall inform the claimant of such dismissal and whether an appeal is available against such dismissal. If the claim appears to be inadequate or insufficiently clear, or if the claim form is not filled in properly, in these cases, the court shall give the claimant the opportunity to complete or to rectify the claim form, or to supply supplementary information or documents, or to withdraw the claim within such period as it specifies. So at this stage, this is possible without the consent of the defendant, and the withdrawal of the claim does not preclude the claimant from asserting his claim again for example, under national law, or for example, in a European order for payment procedure. And for this purpose, the court shall use standard form B and set a corresponding deadline, which can be extended once. So here you can see standard form B, the request by the court to complete or to rectify the claim form. So what deficiencies can be improved? The information provided by the claimant is insufficiently clear if it's not conclusive or not comprehensible. The information provided by the claimant is inadequate if mandatory text fields are left blank. So, for example, if the claimant fails to provide relevant information about the evidence, and the claim form is not filled in properly if the claimant uses a language other than the official language of the court for this purpose, or the claimant has not signed the form. Can the court requirement require documents as part of an improvement order? So the claimant needs only to describe and to substantiate the evidence, not to attach it. So evidence may be attached if necessary, but there's no such obligation, and it follows that the court cannot require documents under an improvement order. So yeah, here you can see standard form B, and for example, if you use the wrong language, the court will ask you to fill in the correct one. How's the procedure conducted? So according to Article 5, Paragraph 1, European Small Claims Procedure, the procedure in principle is a written procedure. So the information which the court will consider will be in writing, and no presence in the court is needed. However, the court itself may hold an oral hearing if it considers that this is necessary in order to decide the case. And also that the claimant and the defendant have the right to request a hearing. If such a request is made, the court must hold a hearing unless it considers that it is not necessary for the fair conduct of the proceedings. And the reasons for refusal shall be given in writing, and this refusal may not be contested separately from a challenge to the judgment itself. Where an oral hearing is considered necessary in accordance with Article 5, Paragraph 1a, European Small Claims Procedure, it shall be held by making use of any appropriate distance communication technology, for example, video conference or teleconference, unless their use is not appropriate for the fair conduct of the proceedings. Then, according to Article 8, Paragraph 2, European Small Claims Procedure, a party summoned in person may request the use of distance communication technology if this technology is available at the court. And also, according to Article 8, Paragraph 3, European Small Claims Procedure, a party summoned to the electronic hearing may request to be physically present at that hearing. And the decision on this issue is left to the discretion of the court. But the costs of a personal hearing are usually out of proportion to the claim. And according to Article 16, European Small Claims Procedure, the court shall not award costs to the successful party to the extent that they are disproportionate to the claim. So therefore, electronic means are preferable. After receiving the properly filled in claim form, according to Article 5, Paragraph 2, European Small Claims Procedure, the court shall fill in Part 1 of Standard Form C, and the court shall send the defendant a copy of the claim form and, if applicable, the supporting documents together with the answer form thus filled in. And these documents shall be sent within 14 days of receiving the properly filled in claim form. And here you can see Part 1 of Standard Form C. Then, according to Article 5, Paragraph 3, European Small Claims Procedure, the defendant shall submit his response within 30 days of service of the claim form and answer form. and he can fill part 2 of standard answer form C or respond in any other appropriate way. So for this purpose, there's no obligation to use the standard form. The defendant shall respond to the claim in the language of the court which has sent him this form, and the response must be in writing. And the obligatory content from this response does not result from Article 5, Paragraph 3 European Small Claims Procedure, but from the answer form C itself. And like the claim form, this form also contains instructions and guidelines for the defendant. For example, please note that if you don't answer within 30 days, the court shall give a judgment, or please make sure that you write your name clearly and sign and state the answer form at the end. Or you can indicate possible means of evidence and add supporting documents. Or if you want to make a claim against the claimant, a counterclaim, you should fill in and attach a separate form A. So if the defendant responds within the time limit of 30 days, a copy of the response and its enclosures shall be sent to the claimant within 14 days. If not, the court shall give a judgment. The court must proceed as quickly as possible, but the deadlines set for the court are not fixed. Then, according to Article 5, Paragraph 5 European Small Claims Procedure, there's also the possibility for an intermediate procedure on the value of the claim. According to this article, the defendant can claim that the value of a non-monetary claim exceeds the limit of 5,000 euros. In this case, the court must decide within 30 days of sending the response to the claimant of whether or not the claim falls within the scope of application of the European Small Claims Procedure, and this decision cannot be contested separately. Yeah, as already mentioned, the defendant can file a counterclaim. To do so, he must use claim form A, and the counterclaim shall be examined in the same way as a claim, and it must also be within the scope of application of the regulation and must not be clearly unfounded or inadmissible. The concept of the counterclaim is to be interpreted in accordance with Article 8, Paragraph 3, Brussels 1A regulation as arising from the same contract or facts on which the original claim was based. So connexity is required in this case. If the counterclaim does not fall within the scope of application of the regulation, for example, because it relates to a claim under employment law, and this is an exclusion in accordance with Article 2, Paragraph 2 European Small Claims Procedure, then the claimant would have to be informed and national law would apply. If the requirements for a counterclaim are fulfilled, then the court of the main action shall have jurisdiction. So the counterclaim shall be sent to the claimant within 14 days of receipt. Then the claimant shall have 30 days from service to respond to the counterclaim. If he fails to do so, the court shall render a judgment on the counterclaim. If the claimant responds, the answer of the claimant shall be sent to the defendant within 14 days after receipt. Which languages can be used in the procedure? So according to Article 6, Paragraph 1 European Small Claims Procedure, the claim form, the response, any counterclaim, any response to a counterclaim, and any description of relevant supporting documents shall be submitted in the language or one of the languages of the court. So only the description of the supporting documents shall be submitted in the language of the court, but not the attached evidence itself. Otherwise, a description would not make sense. Are foreign language documents admissible? So documents that do not fall under Article 6, Paragraph 1 may also be submitted to the court in another language, and primarily this includes written evidence. So if any other document received by the court is not in the language in which the proceedings are conducted, the court may require a translation of the document, but only if the translation appears to be necessary for giving the judgment. And the idea behind this provision is to avoid unnecessary translations. That means translations that are not relevant for the judgment. Then, according to Article 6, Paragraph 3, European Small Claims Procedure, a party may refuse to accept a document because it is not in the official language of the place where service is to be effected or to which the document is to be sent, or in a language which the addressee understands. So in these cases, the court shall inform the other party to provide a translation of the document. The court itself does not provide the translation. So the purpose of Article 6, Paragraph 3, European Small Claims Procedure is to protect the addressee from disadvantages that may arise if he is served with a document written in a language that he can't understand. The text of the regulation does not contain a time limit within the recipient must exercise his right to refuse acceptance, but according to recital 19, a party may refuse to accept the document at the time of service or by returning the document within 1 week. How is the procedure concluded? So according to Article 7, Paragraph 1, European Small Claims Procedure, the court shall give a judgment within 30 days of receipt of the response from the defendant or the claimant, if a counterclaim is submitted. So this is the principle of immediate judgment. If the case is not ready yet for decision, the court shall demand further details concerning the claim from the parties. In this case, the court shall set a time limit which may not exceed 30 days, or take evidence in accordance with Article 9. We will talk about this later in a few minutes, or summon the parties to an oral hearing. The oral hearing must take place within 30 days of the summons, and in this case, the judgment shall be given within 30 days after the oral hearing. These three measures can also be combined with each other, and as soon as a decision is ready as a result of the measures, the court shall give a judgment within 30 days, in reality as soon as possible, and then the judgment shall be served on the parties in accordance with Article 13, European Small Claims Procedure. How does the taking of evidence take place? So the court shall determine the means of taking evidence and the extent of the evidence necessary for its judgment, and it shall use the simplest and least burdensome method of taking evidence. So the principle of written form shall be observed as far as possible. The court may admit the taking of evidence through written statements of witnesses, experts, or parties. So the principle of immediacy does not apply here in this case. Where the taking of evidence involves a person being heard, that hearing shall be carried out by using electronic communication, for example, video conference or teleconference. The court may take expert evidence or oral testimony only if it is not possible to give the judgment on the basis of other evidence, and a maximum duration of the evidence procedure is not regulated in the European Small Claims Procedure, but the aim is to reach a decision as soon as possible. Then, according to Article 10, European Small Claims Procedure, the representation by a lawyer is not obligatory in the Small Claims Procedure. This refers only to first instance proceedings, not to any appeal proceedings. So in appeal proceedings, this is determined in accordance with national law. What are the basic principles of the procedure? So the court shall not require the parties to make any legal assessment of the claim. So the parties are not obliged to make legal statements or to refer to norms. their task is limited to the preparation of legally relevant facts. If necessary, the court shall inform the parties about the procedural questions. So, for example, if the court sets a time limit, the party shall be informed of the consequences of not complying with it. And whenever appropriate, the court shall seek to reach a settlement between the parties, but only when it seems appropriate or convenient. And the court settlement attempts may also be made in writing, so no oral hearing is necessary for this purpose. Possible methods of the service of a claim, a counterclaim, and the judgment are by postal service and by electronic means, but by electronic means only if it is technically possible, if it is permitted in the state where the proceedings are conducted, and if it is admissible in the currency where the service is effected. And the service shall be attested by an acknowledgement of receipt, including the date of receipt. The European Small Claims Procedure's aim is to ensure that judgments are enforced as quickly as possible. So according to Article 15 European Small Claims Procedure, the judgment shall be enforceable notwithstanding any possible appeal. So an appeal shall not have suspensive effect, and the provision of a security shall not be required. A certain compensation for this procedure of enforcement is achieved by Article 23 European Small Claims Procedure. So this is the stay or the limitation of enforcement. So according to Article 23 European Small Claims Procedure, upon application by the party, enforcement may be suspended or limited if a party has challenged the judgment, or such a challenge is still possible, or a party has requested a review of the judgment according to Article 18 European Small Claims Procedure. We will talk about this review in a few minutes. So the court with jurisdiction or the competent authority in the member state of enforcement may limit enforcement proceedings to protective measures or make enforcement conditional on the provision of such security as it shall determine, or stay the enforcement proceedings under certain conditions. Then, according to Article 15A European Small Claims Procedure, the court fees shall not be disproportionate and shall not be higher than the court fees charged for national simplified court procedures in that member state. And the member states shall ensure that the parties can pay the court fees by distant payment methods, which allow the parties to make payment also from a member state other than the member state in which the court is situated, by offering at least one of the following methods you can see here on the slides, or for example, a bank transfer, credit or debit card payment, or direct debit from the claimant's bank account. According to Article 16 European Small Claims Procedure, the unsuccessful party shall bear the costs of the proceedings, so the own costs, but also those of the opponent. And this basic rule is limited by the second sentence of Article 16 European Small Claims Procedure. So in this sentence, the court is instructed not to award costs to the successful party if these were not necessary or disproportionate to the claim. So we talked about this regarding the request of a party summoned to an electronic hearing to be physically present at that hearing. So in these cases, electronic means are preferable. If a party only partially succeeds, the court may order each party to bear its own costs or to order the parties to share the costs equally. What about lawyers' fees? Are they recoverable despite the representation by a lawyer is not obligatory in the small claims procedure? So in principle, yes, but they must be proportionate to the claim, and the court shall not award any costs that are disproportionate. So yeah, in principle, yes. Then, according to Article 17 European Small Claims Procedure, member states shall inform the Commission whether an appeal is available under their procedural law against the judgment given in the European Small Claims Procedure and within what time limit such appeals shall be lodged. So the regulation leaves it to each member state to decide whether it allows appeals at all against judgments under the scope of application of the European Small Claims Procedure. So, for example, the Austrian legislator has not created any implementing provisions regarding the appeal procedure and also how any appeal procedure is structured. So the domestic regulations of the law on appeals apply without restriction. Then Article 18 European Small Claims Procedure provides an autonomous procedure in the case that the defendant was unable to contest the claim. So a defendant who did not enter an appearance is able to apply for a review of the judgment before the competent court of the member state in which the judgment was given. And this is possible if the defendant was not served with the claim form, or in the event of an oral hearing was not summoned to that hearing in sufficient time and in such a way as to enable him to arrange for his defense, or if the defendant was prevented from contesting the claim by reason of force majeure or due to extraordinary circumstances without any fault on his part. So, for example, in the case of natural disasters. But if the claimant failed to challenge the judgment when it was possible for him to do so, the review of the judgment is not possible. No form is provided for this application, and the application must be filed with the competent court of the member state in which the judgment was rendered. The time limit for the application is 30 days, and it begins from the day the defendant was becoming aware of the judgment and was able to react, at latest after the first enforcement action, and no extension of this time limit is possible in this case. So what options does the court have? If the court rejects the application for review because none of the reasons in Article 18 European Small Claims Procedure is given, then the judgment shall remain in force. If the court decides that the review is justified, the judgment shall be null and void, and an appeal against this decision is not possible. Then, according to Article 20 European Small Claims Procedure, a judgment given in a member state under the European Small Claims Procedure shall be recognized and enforced in another member state without the need for a declaration of enforceability. So this is the principle of immediate enforceability and without any possibility of opposing its recognition. In any event, no review as to the substance is allowed in the member state of enforcement, and the judgment shall be enforceable regardless of the possibility of an appeal. Although the judgment issued in the European Small Claims Procedure is a special European enforcement order, for example, like the European Order for Payment, a certificate is necessary, and this certificate must be presented at the member state of enforcement. So at request of one of the parties, the court shall issue a certificate concerning a judgment given in the European Small Claims Procedure using a standard Form D, and the request for this certificate can already be made with claim Form A, but also at any time later. Yeah, here you can see standard Form D, the certificate concerning a judgment in the European Small Claims Procedure. And upon request, the court shall provide the party with the certificate in any other official language of the European Union by making use of the multilingual dynamic standard form, which can be found at the European e-Justice portal. So here you can choose all available currencies in the European Union, and then you can select, for example, all small claims forms in English or any other official language of the European Union. According to Article 21, paragraph 1, European Small Claims Procedure, the enforcement procedures shall be governed by the law of the member state of enforcement. So any judgment given in the European Small Claims Procedure shall be enforced under the same conditions as a judgment given in the member state of enforcement. And the party seeking enforcement must provide 2 documents. A copy of the judgment, and in this case, a proof of authenticity is required, and the certificate referred to in Article 20, paragraph 2, European Small Claims Procedure, and when necessary, the translation thereof into the official language of the member state of enforcement. Under what conditions can enforcement be refused? So upon application by the person against whom enforcement is sought, enforcement shall be refused by the court with jurisdiction in the member state of enforcement if the judgment is incompatible to an earlier judgment given in any member state or in a third country. So this is called a title collision. And this is the case when the earlier judgment involved the same cause of action and was between the same parties. And the earlier judgment was given in the member state of enforcement or fulfills the conditions necessary for its recognition in the member state of enforcement. And the incompatibility was not and could not have been raised as an objection in the court proceedings in the member state where judgment was given. And these 3 requirements must be met cumulatively. So here you can see a short summary of the small claims procedure. I will not go through it now. Maybe you can take a look afterwards. Maybe it helps to visualize the procedure. That's it for my part. Thank you very much for your attention. How can I stop this?
Just click here.
So do we have a break, right? Because it was foreseen 15 minutes between. You want to continue?
So it's actually more fun. I can continue.
Yeah. No.
Okay, so you need to put this.
This is about mine. So which one is mine? Okay, it's only
Okay, this is G.
Okay.
Open it, and then let me just show you how to share it.
Yes.
I'm not sure if it's being shared. Okay. Okay. Maybe we can select slideshow.
And then we go
from the beginning.
perfect. Yes,
Yeah.
exactly.
Okay.
And we should maybe we should do this. Okay. Sorry.
So here's it.
Dobar dan. Hello from us. My name is Martina Arnett. I'm the head of the District Court for Commercial Matters in Vienna. My court is the exclusive court for the European Payment Order in Austria. we started 2009 with 2,000 European payment order. Now we have 5,000 per year. In Austria, the small claims procedure is spread over all district court in Austria. So we had 2009, nearly 200. Now we have 400 per year. It's not very much. I don't know why, but maybe it's because there's a central court. I can tell this. We want to show you a little. We want to ask you. Do you have questions for Eva's part? No. Okay. If you have questions, please, people at home, write it in the chat or just ask something, because we don't want to stay here and talk and talk and talk.
Yes, thank you. Dobar dan, hvala lepa. I'll go on in English. My Croatian is not that good to have a presentation in Croatian, but I'm happy to be here, and it's wonderful in this autumn. And I'm very happy to give you some insights on the European small claim procedure from the attorney's point of view, and as well on the European payment order, and some insights on the enforcement, which we'll talk on Friday afternoon. I'm an attorney admitted to the Austrian and the Slovenian bar, and our law office is known in the region as the law office being able to serve clients from the region, which means the entire ex-Yugoslavia. All my colleagues, we have knowledge in the languages, and we are really specialized in cross-border, any kind of cross-border issues in collecting claims and so on. And we also do have experience with the European small claim procedure, and I brought you a case which we had in Germany, where we brought this European small claim procedure, and where we, at the end, where we were awarded a final award, and then of course on the basis of this we could go into the enforcement procedure to get the money paid. Yeah, I think that's for the moment, for the introduction. We really tried to keep our presentation with practical aspects, how you should deal or how you should start. Of course, the European regulation provides the legal framework, but it's always a question how to deal with it, because when you first have to apply, or when you first decide with your client that you will go for your European small claim procedure, which is a good option, then you have to fill in the forms. And the first time when you got this form there, and you have to tick aspects, and then the court is not satisfied and please, and has additional questions. So with Martina, we thought maybe it's a good idea to go in the first that you go through the forms.
Yeah, and so you try to fill in a form, so you see how it works. Yeah, because you shouldn't need a lawyer to do this, but if you look at the form, sometimes maybe you need one, or you should study law. So we prepared some questions, and we have a case, but we should start with just.
I would say my suggestion would be, we have this, I guess you got this in the material, the cases, and there is in the material also the standard form. So we thought, on the homepage of eJustice, it's written that the average time to fill in this form is 30 minutes. So, but okay, we will not use 30 minutes to fill in this form, but our suggestion would be on the basis of the first case, which is in the materials, which is the road accident in Germany, is case number 1, where it says there's a road accident in Germany when another party was involved, and
it's 0.5 if you look for it.
Maybe we should just fill in on the basis of maybe littera B, the European small claims procedure, and then we would just go through and we'll see what we are paying attention to when, or what I'm paying attention to when I'm as an attorney filling it in for my clients, and what she Martina as a judge is paying attention to and what is important to her. So maybe a few minutes that you just go through it.
We have only 3 people we see, so these 3 people here should do this really.
On the other hand, you got also the links. They were provided in the presentation of Ms. Wolkensteiner, and in our presentation at the end, which you can also get, of course, afterwards. There are the links, useful links for these procedures, where you can get all these informations as well. And
You want? So everyone can see it. Yeah. Where's the word up? No, it's not the PowerPoint. No. We can leave the PowerPoint. Okay.
I think it was in the materials.
Yeah. We hope that the people at home try it too, but if you don't have any materials, just look at the homepage.
Or just write into Google form small
Claims procedure.
form A, and you will get the right form. Yes. Huh?
The email address is Justice Europa EU. Yeah, now you see. Just try it. Yeah, yeah.
Read it.
Yeah.
It is from our participant. We have a question from our participant,
Yeah.
Andrei Perušić. Dear lecturers and participants, under Article 4, Paragraph 5 of Regulation, the member state is required to provide a claim form available in all courts, where one can launch a European small claim procedure. How do the courts fulfill this obligation?
Article 4.
Yes, Paragraph 5.
In Austria, we have the Amtstag, which is a day where people can come to the district court and ask for help. And so people can come and say, I want to do this. And judges or practitioners help them to fill out the forms. We just print them out and we fill them out. So that's no problem for us. But I have to say, in the beginning of these proceedings, judges didn't know the procedure. So I heard we had an European consumer company which sent people to the district courts to start small claims procedures, and they came to a district court to Vienna and said, oh, I want to make a small claims procedure. I'm a consumer, and someone said to him, we don't know this, we won't do this. Yeah, but now I think it's 10 years, more than 10 years after the start, it's getting just more useful. Yeah.
And people are getting really used to it. There is a lot of information as well on different homepages from the commercial chamber and so on. And as well on the homepages of the European Union, they provide very useful information. There is also a practical guide. So yeah, people are much more aware that it exists, this procedure, they're making use of this procedure. And of course, as well in courts or wherever you can seek information.
But in Austria, people like more the European payment order. And you have to know that in some scopes you can choose if you do the payment order or you do the small claims procedures. So it depends whatever you are used to or you like more. As a lawyer, for example.
I mean, maybe I can add something. When clients, from the lawyer's perspective, when clients are coming to your office and they want to have, they want your information, whether they have a good case or not, whether they shall go on or they shall not go on. I mean, the small case procedure for 5,000 euro, of course, this is a lot of money for the clients, but the issue is that actually, if you start calculating also the costs, the attorney's costs, the court, very quickly at the amount of 5,000 euro, which means that quite often or sometimes clients decide not to go on because at the end, if you launch a procedure at the court for amount which does not exceed 5,000 euro, there is the practical aspect where clients say, okay, was bad luck, so will not go on because they have this risk for that they will bear the cost, because at the end, of course, you do not know how of course, you try to evaluate, but you never know from the circumstances. All lawyers and all attorneys who are listening, I'm sure you had a situation that you, but then all of a sudden evidences are turning out which are turning your case in a very weak one. And of course, the client in this case will have to bear the cost. So sometimes they just simply do not decide to go for court that would not exceed 5,000 euro.
Yeah, but I think the procedure was, yeah, but I don't know if it really works without a lawyer. There are people who know, and they can fill in the forms and they can bring in the forms, but I don't know. You can try if you really write it down. Are there any more questions from our people outside? It's a little bit spooky. Hmm?
Perfect. I think we've got some minutes to go through the formula and to have a look into it. And I think together to fill it in and then to answer the questions which we have prepared for you as well. Yeah, to have kind of a training session and to add, of course, our practical knowledge.
At first, you have to find the court, I would say. Yeah?
Yeah, the first question is, what is the competent court? This is, I think this is the fundamental question in cross-border relations. I'm always underlining this because it seems something for lawyers who are working. We are checking when it comes to a cross-border case. And what is a competent court? This is the first question we are always checking. But actually, for the ones who are not working that much in cross-border relations, but who might have cross-border cases, they are not paying maybe that much attention to it. So therefore, the first question is, which court is the competent court? And the appropriate answer to this is provided by the Brussels A1 regulation, where it says what is the competent court. So first of all, you have define, of course, the country of jurisdiction, the forum where you have to bring this A1, 1A, the regulation. This can be decided. Maybe we should.
Yeah. And maybe that's a difficulty for just a consumer. Maybe, yeah. But we can just try. If what do you think here?
Can I just add one thing to the competent court? I think the most important provisions are of course, first of all, that where the person who is sued is domiciled, so this would be the competent court, and then you have, of course, special jurisdictions in the case of a sales contract. I think this is the most important exemption, and the second one, the service provision agreement. And for sales contracts, the competent court is the court where the service, the delivery took place or should have taken place, and for services where the services should have been provided or were provided. So this is basically, I think, the most important exemptions. And for a Croatian, I will give you another insight as a lawyer, as an attorney. You can also, of course, agree with your client on jurisdiction. So you can, in your agreement or with your contract, which you conclude with your client, provide for a provision in which you stipulate for the competent court. Austria has minorities, and in Burgenland, the Croatian language is official language as well. And there are courts in Burgenland, in Oberwart, which is in Croatian Barta, and this court is a Croatian court, which means that if cases are filed and lodged there, and you request that this case will be proceeded in Croatian language, you could be heard there in Croatian language. So why I'm saying this is not just something which is I'm saying you out of fun and it's nice and okay, I do very often see in cross-border relations that the Austrian contractual partner wants to have jurisdiction subcontractors or contractors or whatever. They are not in a really strong bargaining position. They do not have really strong bargaining power. So there is always the clash. So you simply have to accept the will of the Austrian contractual, a court in Vienna, in Salzburg, and wherever. But of course, the issue is that you are much more familiar with your Croatian legal system and the functioning of the Croatian courts. And in addition, there is the aspect of languages, because if court in Vienna or whatever, everything is done with yes, but still you have the possibility.
No, I know.
It's
No,
the
I just want to tell that no.
Yeah, but it's a court where you can request this, and you can. It's a question also who has to bear the cost for the translator, because Vienna, then you will have to bear the cost. Though there is a translator, it's going to be the court who has to pay, and you don't have to get this advance payments, which are
Make a try.
Make a try. We are always doing this funny things because this is something we like to do. And you can also rely on as a Croatian citizen. So it's not necessary that you're Austria, but also on the basis of judgments of the Europe. You can rely on this and you can invoke this, that your case will be there in Croatian, of course. So this might be a way how to circumvent this clash.
Okay. So back to the small claims procedure. We need a court. So what do you need for this, to find a court? Can you have your procedure in Croatia?
One of the most important aspects.
That's my question. The accident was in Germany. The other part is German.
So
have you any chance to have a procedure here?
No.
No, we will. If nobody else will answer, we will answer our questions.
Of course not. You can invoke a small claim procedure only if there is a cross-border element. It was already stipulated. Mrs. Wolkersdorfer said it before in her presentation. It's element, and if you're a Croatian holder of a car, of a vehicle, and you got a car accident in Germany, this element of the cross-border aspect is fulfilled. So, okay, we have the first aspect that we have a cross-border and we can rely on this procedure. We can invoke this procedure. The second element is, of course, then where in Germany or where you have to sue.
Where you have two courts. You can choose
different courts.
What do you need? You need the zip codes. The first one, maybe you went skiing, I don't know. You had your accident in München, and your German other part lives in Hamburg. Which court you choose, Hamburg or München?
Any suggestion?
Or Hamburg, yeah. If you like Hamburg, you take Hamburg. If you like München, you take München, because in München there was the accident, and in Hamburg lives your. Oh, so if you like to go to Hamburg, go to Hamburg, yeah. So you put you choose the site, put in the zip code, and it will tell you, I don't know, Amtsgericht Hamburg West or Amtsgericht Hamburg, I don't know, yeah.
This is a very useful link as well on the homepage. I will show it to you, where you can enter the competent court. So I hope we're gonna find it right now very quickly. Once back.
No. Yeah.
There is an application on the homepage, and there you can put additional information.
Small claims. Show you. You just have to click around and
look at it. With the information here, you can see how it works in all. And one should be also the competent court. Anyway, there is a form, and you can see from this form you simply enter the zip code or the area, and the computer and the internet will show you which is the competent court. address where you can send this form once you have filled it in.
We will show you tomorrow with the European
Yeah,
payment
very
order.
hopefully.
It's the same. It's the same page.
Okay, and then you go through this formula. You fill in the competent court. In addition, you provide the information on the claimant with all details, name, address, country code, phone number, and email address. I think email address and
I would say the phone number is very important because sometimes we try from the court just to make it easier and phone people if they forget something. Phone number, it makes work easier for us.
exactly. Are required as well for the respondent. So the same name, of course, address, very important, country, phone number, and that's it. These are the basic information which you have to fill in. And now it's getting legal. The first point. And in this formula, you have different suggestions, and you think is the right one.
And which one would you choose for Hamburg? And wonderful. Yeah,
Exactly.
so you have just to make a cross, and that's wonderful. Yeah,
Or you can also choose if you want to go for München and you would like to have the procedure in München, you would choose the place of the accident of the. Point number 5, the cross-border element. You have to fill in why this is a cross-border element, so where the parties are located, why is this a cross-border element. The one is the claimant, in this case, let's say, is located in Croatia, whereas the respondent is located, has its habitual residence in Vienna, in Hamburg, or the accident happened in the harmful evidence.
but having this, and this is not filled out. Yeah, the claimant is from Croatia, and the defendant is from Hamburg. I mean, it's a cross-border case. Yeah, it's no use to send it back and say you didn't fill in point 5. Yeah, so that's if it's clear, you don't have to make many noises about it. That's what I want to say for the judges.
But
here.
this is Martina, who is a very open judge. You have also other judges who are very formalistic and who were taught get rid of as many cases as you can. And so they will say, no,
Yeah,
you
but
have
maybe
to,
it's better you have your
yes,
phone
you are.
number, and you maybe, I mean, it's easier. I just want to say it's easier. Yeah. And if judges are listening, I hope you kill the procedure if you're too formalistic. It's for the European payment order too. That's just I want remark.
Definitely,
For
absolutely. I absolutely agree. It's stupid to keep it too formalistic, but nevertheless, from a lawyer's perspective, try to fill it in whatever you can. Don't try to miss aspects. From my view, it's easier to fill in the online form, because so you go through all the specific aspects you are required, whereas this paper form is not really
it makes you a little bit dizzy if you read all this and then you have to make crosses. Yeah.
Exactly. Okay. So the next aspect which you have to fill in is the details of the bank and how you want to pay the court fees. I can tell you a story with this respect. When this procedure started, and of course, so we tried to file all procedures all over Europe, so it was fun for us to do so. One day we filed one procedure in Venice, And all of a sudden we received a letter from the court in Venice stating we shall send a colleague there, because they still had these court stamps which had to be put on the application. And we said, yeah, but we want to transfer the money. It's no problem. We're going to pay it. So just please let us know the bank details, and we will transfer the court fees. No, Venice insisted it's not provided for. It was not provided for at that time in the Italian legal court system. So we had to engage a colleague in Venice, asking him to go to the court with the stamps and putting the stamps on the application. So which is absolutely contrary to this procedure, which should be easy. But this is one of the stories which happened when these procedures were introduced. But on the other hand, it works really, really well in the Baltic countries. They are really very much up to date with this, and it works quite well over there. So, okay. Yeah.
About your claim. Yeah, you just have to say claim for money, amount of principal. You can choose the currency, kuna. Other claim, you can have different claims here, not only claims for money. That's maybe a little bit complicated to put it in the small claims procedure, but you can do it. What you can do with the European payment procedure, you can do it here.
I brought you one case which is a claim for a compensation due to as a consequence from a car accident, or actually an accident when cargo was uploaded and unloaded. So maybe it's interesting just if I just tell you how the court in Germany, in Aschaffenburg, was dealing with this request, because there is not that much place where you can fill in. So what's actually the reason and what happened, why you are claiming this specific amount. And what we did, of course, so we filed this small claim procedure as well. There was an issue that there was the cargo uploaded and one person was standing there, and then for some reasons an accident happened anyway. So, and this person was also in sick leave and so on. So, and this person the claimant wanted to get compensation for what happened there. So, and in the application form, we try to argue, very briefly to say what happened and that we want to have this compensation due to this accident. And then a couple of weeks later, we received from the court a writing where they say, please be so kind and specify what actually was really, and they wanted to get, the court wanted to have more information. So when it happened, where it happened, on the circumstances, why we are claiming specific amounts and so on. So, and we received this additional writing, and we reply, of course, we reply to it, and that's actually it with this respect. And it's everything in writing, just put the entire story more precisely, including the documents which are, or the proofs which are proving your request. And we added the proofs actually in Slovenian language. It was a Slovenian client, and we did not add any translation of the proofs.
Yeah, judges are used to their national procedures, so they, in a certain way, want to have, yeah, if they need more information, they just ask for more information.
Exactly.
Sometimes there's not so much place in the form, so you have do an appendix and write some more. Okay, the interest. Are you claiming interest, yes or no? That's, for example, very complicated. I see it with people who have no lawyers. They don't know what to write there, how to put it there. But the rate, yeah, and sometimes people don't know which rates they can they can have what is the interest, the statutory interest for consumer claims, or for in Germany or in, I don't know, Croatia, and some of my colleagues said we have 4%, and in German I think it's 5%, and some sent it back and said, oh, the interest is wrong. Yeah, maybe sometimes it's better you write down which interest you want. You say, okay, the interest is
For consumers.
yeah, it's for consumers, or it's the interest by Croatian law. Yeah, so someone can look if it's right. Okay.
And very important, also add the date from when on you want to have these interests. That's important to add.
Yeah.
We already have said something on the details of the claim, where we said, okay, you need to put your story. What is the reason? What are the facts of your claim? The problem with this aspect, with this point number 8, is the translation or the language, because at the end, when you fill it in the form, you can convert it to any other language. So if you would fill it in Croatia for Germany, you can work on the basis of a Croatian form, and at the end you just simply the computer converts it into German, so you'll have the German formula which you will send to Germany, to the German court. The issue or the problem is that the text which you put it there, the word, the story of your claim is not going to be translated. So this is an aspect.
Problem.
This is really a problem.
I mean, you can try to translate it with DeepL, is the new super translation program. That's much better than Google Translate, I could say. But the problem is you have to, in Austria, you need to bring it in German. Yeah. So
except in Oberwart.
Yeah, exactly. Oberwart in some parts of Carinthia, but you should. That's a little bit of the problem, that you should use in a way not so many words, but you have to explain. You need more words. That's a little bit of difficulty.
And the consequences, of course, if the other party of the respondent would receive this form in his language, in the official language, but there is something in a language he would not be able to understand, he can refuse it. So which means that the claim would not be handed in to the respondent, and this is really an issue. So on the one hand, the suggestion would be use as less words as you can, so just simply use figures if it's possible, but with a small claim procedure this is actually not possible, because you have to explain. And
I mean, it's just much more better with European payment order. That's maybe why it's much better in use. But yeah,
it's indeed an issue. It's because, as I said, the respondent may refuse the acceptance, and then you have a problem because it has never been handed in, and in principle the procedure cannot get started because it was not handed in.
So yeah, then you have written evidence, witnesses. You have to just write them down.
Maybe in this case which I brought you, there was really a procedure which was in writing. There was no oral hearing, so really on the basis of the evidence which was brought to the court, the court then finally eventually decided.
But I think for European judges, it's not so easy to decide without a hearing. Yeah, in a procedure. Yeah, and I think you can't receive a settlement without a hearing, because I don't know how to do this. I can write them, please make a settlement, but I don't think it works.
But of course, you can request an oral hearing, and if the court thinks or deems it appropriate, they can still do it, and of course by video conferences as well, and any electronic means. Of course, you have to agree if you want to have, or you agree to the electronic means of communication, which is very important. And then I would like to draw your attention maybe to point 11, which relates to the certificate, because the certificate is the basis on which you can enforce such final award in another country. And this is really something, I think, really very important and arising from European law is that you really can get these certificates, and the awards are getting tangible within the European Union. And you can also request this award, this certificate, which will then be the basis for the enforcement procedure in any language. And the court will issue, for instance, if, as in our case, you filed a claim in München or in Germany, and you also can ask the judge in München to issue this certificate in Croatian language, for instance, because you know that you will have to conduct enforcement procedures in Croatia, and you will have to have this document in Croatian language because it's the official language, and therefore you can also ask it in Croatian, which reduces this translation aspect.
Yeah, and you can get it in each language, really.
Indeed, it's indicated. You can indicate in which language you want to have it. In Bulgarian, German, Italian, whatever you want. So you simply indicate and you will get it. And this makes things in the enforcement procedure really so much easier because you don't need this translation. And then you sign this document on the point 12, put the date.
And you have to sign it, maybe.
That's very important. You really have to sign it. So it's not just, you really have to sign it. Don't put just your name. Add the bank details for the transfer of the court fees, and that's actually it. And once you have filled it out, as I said, on the homepage of the European Union, it's provided that it takes 30 minutes to fill out this form. You simply print it out, add the evidence which you think it's necessary, and you just file it to the competent court, to the court who is going to decide. Maybe one thing how you are going to file. We are usually, when we file it, we usually file it by ordinary mail with the receipt, with the confirmation of the receipt, because we want to be sure that it was indeed handed in, that we really filed it at the court. So we still rely on this traditional means of communication. Once then the procedure is ongoing, we can also communicate via email. That's absolutely no problem. But the first step, we will definitely, as attorneys, we will definitely rely on the traditional means of communication, meaning to take these services of the post.
Yeah, you should really try postal services because all these electronic things are not really working yet. These e-justice projects.
I mean,
I wouldn't trust them, but you can try if you like. But now they told us, for example, they just cut it, these line Austria, Italy, nobody knows why.
I mean, as an attorney, we attorneys in Austria, we are connected with all courts and all colleagues. We are connected with a special program which is called WebRV, and we are handing in submissions, claims, and whatever with this program. But of course, we are, for instance, not connected to Germany, to the courts in Germany, other countries. And if we have to sue in other countries, we will always really use the postal service with the confirmation, because the consequences as well that it has a consequence on the time and on the limit. So once you file, of course, then you filed in the time, the time calculation starts or ends or whatever. So that's why it's important that you're really sure, especially if the claim is brought towards the end of the time limits. So it's good that you really have this confirmation that everything is okay.
Yeah, and if you didn't hear any, I don't know, I would say 3 months, if you didn't hear anything, maybe you should phone there and ask what happened, but because it can get lost. Yeah, there are files who get lost, or I don't know.
In our case, just as you mentioned, the time limit, in the case which I brought you, which we claimed in Aschaffenburg, we filed in Feb. All the procedure took, I think, 1 second. We filed in March, and the final decision, the award, was handed in May. So it's really quick. So it's 2 months where basically everything is done, and you have the final award. Without the enforcement, of course, but the final award, this is really, really fast.
Are there any questions to the form from the people? I don't know. Maybe they left yet.
I hope not.
Okay, then we just...
Maybe just to have a look. I mean, in the first case, the road accident, the consequences, the damage to the car body, of course, you can use the small claim procedure. In the one case, yes, in the other one, not, because as it was said several times today, 5,000 euro is the limit. So if the damage was below this 5,000 euro, you could, or you can. If it's above, forget about it.
But what would you do?
Is there any
What
way
would you do? Is there any remarks from our audience? What would you do with the 5,200 damage? Yeah, you can try it. Yeah, but you shouldn't write this. For example, if you write this, I reduce it because I want to have this procedure. You will get it back, because in the Austrian civil procedure, it depends on the whole of the amount. Yeah, but which procedure do you have? Do you have other procedures? What can you do? I mean, you could, of course, use the national procedure in Germany. You find a lawyer in Germany and make a national procedure. I mean, we didn't hear about it, but can you do a European payment order? No, it's a little bit tricky. I mean, our message will be, in the end, you don't have to be afraid of these procedures. They are easy procedures. The regulations are short, but you have to read it. And if you read the European payment order, Eva will tell you then, there is for non-contractual claims, there's no European payment order. There's no, and that's a delict. Yeah, that's a little bit. It's like a play. Maybe you just have to. Yeah. Okay. We do number 2.
I mean, the question would be, if you put it like, but you wouldn't state. I would ask you as a judge right now. So if I was a lawyer, and as you said, okay, I would just reduce the amount below 4,800, and I would say, okay, it's 4,800 euro. And then during the procedure, I would just realize, oh no, I have to extend it for another 500 euros. So I would exceed the value of 5,000 euro. Would you reject the claim then?
I mean,
as a
when you are
judge?
in the procedure, I don't think so.
Okay.
But if you have, then maybe you have the wrong procedure. But I think if you tell it in the beginning, there will be no small claims procedure.
Then you would be rejected.
Yeah. If it's later, I don't know, Eva, what was in your if the procedure If they, I don't know, if they have
I
five.
think there is no court practice yet on this issue. It's provided in the regulation. It's 5,000 euro, but nobody really knows. And I think it's a bit depending on the court practice how they are dealing with this aspect. Because as far I know, there is no really European court practice.
That if the lawyer billing exceeds 5,000 euros, then the application shall be rejected.
Yeah.
Okay.
Yeah. She told us. Yeah.
Okay.
You can hope, or you just be quiet
Just
and
try.
just take your 5,000 euros and be quiet if you really want this procedure and don't talk about it. Yeah.
Mm.
So,
All right. So
and a brawl in Spain. We have, if it were 2,000 euros,
it would be okay. It's damages. Compensation, in principle, yes. But the amount is too high. This is exactly the aspect we just discussed. It's 5,000 euro is the limit, and yeah.
okay. And if you own a flat in Budapest, your tenant is not paying the amount. We have 2,000 euro yet. Where can you do a small claim procedure? If you read Article 2, you have we have tenancy of immovable property with the exception of actions on monetary claims. Yeah, it is possible because we have a monetary claim, so there's an exception and you can do it.
So the
Okay,
rent
it's
can be
I.
claimed, but any other aspects in relation to rents, not. There is the exemption provided for in Article 2.
Article 2, point I.
Exactly, point A, yeah, I.
E, tenancy of immovable property with the exception of actions on monetary claims. Yeah, I mean, I just can tell you, you have just you read the scopes and you
And the applicability
and you don't have to remember this
by heart.
If you use this, you just have read it.
Check it carefully, go through it really point by point, and I think then you will succeed. And in addition, if you have not filled in aspects which are required, which are mandatory, you cannot proceed to the next step. The next question is, an attorney draws a legal opinion for a Swedish corporation and charges a fee of 12,000 euro. Is the European payment order, is this small claims procedure applicable?
Let's say it's 4,000 euros.
If it was 4,000, it was applicable. But if it's 12,000, if it's of course not, because it's exceeding 5,000. However, the European payment order could be applicable because it's something which is arising from a claim which is arising from a contractual obligation.
And where do you do this procedure? You are Croatian. Can you do it in Croatia?
Is Croatia?
Yes, the question. And how? If yes, why? How many people home we have? 100.
This might be useful for lawyers who are working for Swedish corporations, Croatian lawyers who are working for Swedish corporations, and hopefully you do not have an invoice which is not paid in the amount of 12,000 euro, but it could happen. So let's go this through.
Is there a way to do it in Croatia? If you are a Croatian lawyer who works in Croatia? Yes or no? our listeners in the third row. Be- But which regulation do you need? Eva told us, which regulation do you need for finding the court? Brussels 1, yeah, and in Brussels 1, do you have what? The place of performance. You can say the place of performance you worked in Croatia, the place of performance in Croatia, yeah. Every lawyer or every person wants to have their proceedings in his country or in her country, because it's much better to be at home there, yeah, because it's very hard to, I think, to do it abroad.
I would add a strategic aspect as an attorney. Of course, you take this into consideration when you decide where shall I go to court. First of all, you take into the consideration the duration of the procedures, first of all. Secondly, of course, you take into consideration that clients might not be that familiar with the legal system, so you take advantage of it. I mean, it's not a big a big aspect what I'm telling you, but of course you are doing so, and it's of course normal that you're taking this into account. Where is it better for me to go to court? Quite normal. And maybe an additional, which we'll touch upon on Friday, and it is, where shall I enforce and under which conditions? Because in Austria, I will talk about this on Friday, but in Austria, it makes absolutely no sense to size a bank account, whereas in Croatia, this is the ordinary means of, and as well in Slovenia, it's the basic or the ordinary means seizing or freezing a bank account during the enforcement procedure. So it's also maybe a question where you want to go, where you want to, which court you want to have competent. These are evaluation which you take into account when deciding on the competent court.
So we can go to the next one. Yeah. You go skiing. I mean, the questions are very similar. Yeah. You have a problem with the Hungarian snowboarder. You want 4,500 euros. Which procedure do you take?
It's quite clear, I think, after what we have discussed. In the one case, we take the small claims procedure, the amount is not exceeded, and the 5,500 is not possible, except if you go and claim just less, and then we hope that the judge will just look over and still not reject it and be too formal if you would extend your claim.
I mean, can I say something here?
Yeah.
I think it really depends on the national rules on how to evaluate the claim that you make, right? In Austria, as you said, of course, it is the total claim. So even if I claim for part of what it's still the total amount, but this could be different in other European countries.
Yeah, so it depends.
So it really depends on how the national of jurisdiction.
Yeah.
But for instance, if you have compensation, if you're claiming compensation in Austria, you will not face the problem with if you exceed the claim, or if you have to reduce, you will not have the consequences, because especially when it comes to damages which are related to injuries or something like this, usually the awarded amount, it will depend on an expert opinion. So it will be an expert who will define how many days you were injured and so on, and what kind of, what were the consequences. And in these cases, according to Austrian law, you will not have the consequence that if you just claim too much or just claim too less, that it would be a big problem. But
it's a cost, the costs of,
it's a question of cost, the fees or the court fees, because the less you claim, the less you will pay of court fees. And the Austrian legal system provides or stipulates that you really have to bring the claim in the amount in the appropriate amount. No, so you cannot just simply claim, okay, €1,000, and then we see how the evidence procedure will go, how the hearings will go, and if I'm really in a bad position, I will just leave it like there, because the consequences, the financial consequences will be less for my client. But if I see things are going well, I would just simply extend the claim. This is something which doesn't work.
So can I ask you a question as a potential?
Sorry.
Yeah.
Sure.
So I would, hello. So I have a question. Actually, does that mean that if I want to claim damages, like physical damages or something, probably the European small claims procedure is not the perfect procedure, right?
No.
So this is not something you would use even in an international context, because you never exactly know how much the damage will be in advance. And so for this is probably not the perfect procedure, right?
Exactly. If there was an accident and the damages, for instance, the consequences were, I mean, in our case, the one which I brought you, there were also damages, but they were really small one, the consequences. It was just, I mean, the person was a couple of days at home, and then he was a couple of days in the hospital at the doctors. And so it was not really that much. But if it is a serious accident, not even a serious, but if it's a bigger one, and you know that you will have to have experts, so from the medical profession, who is going to determine what the consequences are, maybe how we deal with this in Austria, or what in Austria, the damages for physical harm, they are divided into different groups. So you have light harms, you have medium harms, and you have very heavy harm and pain. So this is the three categories. And on the basis of these categories, you would get, so if the expert would say, due to this accident, you suffered 5 days of really heavy, 5 days of really heavy pains, then you would get per day, you would get between 300, 330 euro. However, the expert would have to say that the pain or he would deem that you had pains 24 hours per day. So this is the calculation, the Austrian. So, and I would say, okay, 5 days, very hard pains, second, or this, I don't know, 20 days medium pains, and then light pains. And on the basis of this would be the basis for the awarded damages.
But I would say you only use the small claims procedure if it's not a big accident. If you need an expert, if you think you need an expert, you should do a national procedure. It's no use doing a small claims procedure, I think. Yeah, but if it's only a small damage, I would try it. Maybe your maybe the defendant accepts and said, yes, okay, I pay 2,000 euros and it's ready, you know.
Absolutely. I mean, once you, or especially if it comes to accidents, it's not only just the damages which you are claiming. Usually you also want that the court states that for any further future damages which will arise out of this event, the respondent will be responsible for, and he will, but you cannot say if maybe one day you cannot say in this day when you are claiming that maybe one day there will arising out as well other damages. In this case, you definitely have to go for the national procedure.
Yeah. Maybe you have to come here.
Maybe that the audience is hearing it as well.
If you want to come here, it's no problem. There are no stupid questions. Yeah, you need to sit here. They have to see you. Yeah, you ask your question.
Hello. If your claim is 5,500 euros,
yeah,
and you add a written statement that you are releasing that in amount of 500 euros, then you know that 5,000 euros is something, is the top.
Yeah.
So I think.
Yeah, that's okay. But you have to release it forever.
Forever, yes.
Yeah.
then we can use the European small
Yeah.
claim procedure. The situation is urgent.
Yeah.
We need
Yeah.
a quick answer.
Yeah.
Okay.
Yes. Okay. Thank you.
I mean, it depends. It depends always on the circumstances of the case. You really need to say this. It depends if it's just your, I don't know, your dresses or something which you want to have compensated. It's something different than when it comes to injuries, of course. And of course, you will probably evaluate in a different way if it comes to injuries.
Okay. And point B is your homework. Tomorrow morning, we have the European payment order. And as we saw today, it's very hard to fill out the forms. I don't know. We don't see what the people at home are doing. So maybe just try it in the afternoon or tomorrow morning. Find out, you can choose A or you can choose B, and fill in a form for the European payment order. And we will talk about it tomorrow morning at 10, I think. Yeah? Okay. Are there any questions from outer space? No question. Okay, thank you.
Thank you very much.
Thank you. I would like to thank the speakers for this morning part of today's session. It was really interesting to hear some of the practical points made by our guests here, especially on the part of the court and attorneys, how things proceed before Austrian courts and in practice. So we appreciate a lot your practical approach and introspective presentation that you prepared for our participants. Since we did not have further questions or comments, I think that perhaps we could leave this at this point and then resume our work a bit earlier, if you all agree, at 13 hours, so 15 minutes earlier than we planned. Okay, and that will give us the time to proceed with the topic, but also to have some other questions. So I would like to invite everyone who is with us online or on site to think about possible other questions you might have or comments. And
Experiences as well.
also, yes, very, very, very important. If you want to share your experience with us, that would be also very precious to all the participants, not just the audience, but to us.
If you don't want to ask, they can
Exactly. Yes, as we already informed you, you're welcome to write any of your questions in the chat, even during the break, and then we can pick it up right after we're rejoined again at 13 hours. Dakle, još ću jednom samo ukratko reći da ćemo za sada stati ovdje gdje jesmo, da bismo u 13 sati nastavili s radom, a u međuvremenu ako imate pitanja, komentare ili želju da s nama podijelite neko svoje iskustvo, bilo bi nam to zbilja jako drago. Tako da, evo, biti će prilike odmah nakon što se vratimo i tijekom cijelog sutrašnjeg svakako dana. Tako da, evo. Za sada onda idemo na pauzu i vidimo se uskoro. Hvala vam lijepa na pozornosti.
Hvala vam.
Šta sad? Sad opet niko ne priča.
Okay, hello everyone. So I think we can proceed with the seminar. I will give the floor to my colleague, Eva Polkenstorfer. She will proceed with the topic of European Order for Payment Procedure. So if you have some questions, feel free to type them in chat, or you can turn on your microphone as you prefer. Okay, Eva, the floor is yours.
So thank you. Welcome back. I will just share my presentation with you. Okay. Yeah, perfect.
So you need to go outside. Show. Start sharing it from here.
Perfect.
Okay, and maybe from the beginning. Here.
Perfect. So welcome back. I will continue now with some theoretical aspects of the European Order for Payment Procedure. And yeah, it will take about 1 hour and a few minutes. If you have any questions, you can ask anytime. Yes. So the European Order for Payment Procedure was established in 2008 in all member states except for Denmark. And it allows creditors to recover their uncontested claims according to a uniform procedure that operates on the basis of standard forms. Before the introduction of the European Order for Payment Procedure, the Commission pointed out that the percentage of uncontested claims in the European Union was between 50 and 80% of all court cases. And in about 35% of all payment delays, there was willfulness. So there were a lot of disputes where no contentious questions of facts or law existed between the parties. So all member states have tried to tackle the issue of mass recovery of uncontested claims by introducing a national simplified order for payment procedure. But these procedures were frequently inadmissible to cross-border cases. So therefore, it was necessary to create a uniform European order for payment. The main source of law at European level is the regulation number 1896/2006. And what is not expressly regulated in there is determined in accordance with national law according to Article 26 European Order for Payment Procedure. What were the legislators' aims in introducing this procedure? So the European Order for Payment Procedure has the key aim of simplifying and speeding up litigation regarding uncontested claims across borders within the European Union and to reduce the costs of litigation in cross-border cases. The European Order for Payment Procedure also permits the free circulation of European orders for payment, which are recognized and enforced in all member states except for Denmark. So the aim was to simplify recognition and enforcement. The European legislator also wanted to facilitate access to justice and to relieve the justice. So they wanted to distinguish between contested cases and uncontested ones so that the resources of the justice can thereby be used for contentious cases. And another aim was to unify the proceedings. So with the introduction of the European Order for Payment Procedure, the first steps towards the introduction of a European Code of Civil Procedure have been taken. The aims of the European Order for Payment procedure to simplify, to speed up, and to reduce the costs of litigation and to permit the free circulation of European orders for payment can also be found in Article 1 European Order for Payment procedure, where the subject matter is regulated. What are the characteristics of the procedure? So like the European Small Claims procedure, the European Order for Payment procedure is an optional instrument and offers the litigant an alternative to the domestic and European procedures. So the claimant can choose whether to initiate proceedings under the European Order for Payment procedure or under domestic or European procedures. A European Order for Payment which has become enforceable in a member state of origin shall be recognized and enforced in all member states of the European Union without the need for a declaration of enforceability and without any possibility of opposing its recognition. The procedure is usually conducted in writing, so it is a very simple way of initiating proceedings by filling in and sending standardized forms. And also in the scope of application of the European Small Claims procedure, also in this case, there's no requirement to be represented by a lawyer. The material scope of application is defined in Article 2, Paragraph 1, European Order for Payment procedure. So according to this article, this regulation shall apply to civil and commercial matters in cross-border cases, whatever the nature of the court or tribunal, and it shall not extend in particular to revenue, customs, or administrative matters, or the liability of the state for acts and omissions in the exercise of state authority. So the first requirement is a case in civil and commercial matters. We have already covered this interpretation this morning, so I will just go quickly through it. So according to the European Court of Justice, the term civil and commercial matters is to be interpreted autonomously, and it is the sum of all private law disputes. And two elements are relevant for deciding whether or not the dispute is of a civil and commercial nature. On the one hand, it is the subject matter of the dispute, and on the other hand, the nature of relationship between the parties involved. So in principle, a matter is not civil or commercial when it concerns a dispute between a public authority and a private person, and the public authority acts in the exercise of public power. Then in Article 2, Paragraph 2, European Order for Payment procedure, you can find a taxative or a definitive list of specified exclusions. So according to this article, this regulation shall not apply to matters concerning rights in property arising out of a matrimonial relationship, wills and succession, bankruptcy, proceedings relating to the winding up of insolvent companies or other legal persons, judicial arrangements, compositions and analogous proceedings, social security. And these exceptions, these 3 points, correspond essentially with the exceptions you can find in Article 1, Paragraph 2, Brussels 1A regulation. So this regulation shall not apply to rights in property arising out of a matrimonial relationship, bankruptcy, judicial arrangements, social security. So they correspond essentially. But in contrast to the Brussels 1A regulation, claims arising from non-contractual obligations are generally excluded from the scope of application. We already talked about this at your presentation. For example, claims arising from traffic accidents can therefore generally not be asserted in the European Order for Payment procedure. So according to Article 2, Paragraph 2, European Order for Payment procedure, claims arising from non-contractual obligations only fall within the scope of application of the European Order for Payment procedure if they have been the subject of an agreement between the parties, or there has been an admission of debt, or they relate to liquidated debt arising from joint ownership of property. So in these two cases, the scope of application is open, but generally claims arising from non-contractual obligation are excluded from the scope of application. Which types of claims are admissible? So according to Article 4, European Order for Payment Procedure, the procedure shall be established for the collection of pecuniary claims for a specific amount that have fallen due at the time when the application for a European Order for Payment is submitted. So the proceedings may only be directed at the assertion of pecuniary claims, that means monetary claims, if the claim also contains another demand, for example, a claim for a declaratory judgment, then the European Order for Payment Procedure is not applicable. However, according to Article 10, paragraph 1 and 2 European Order for Payment Procedure, the court may issue an order for payment for the part of the claim which fulfills the requirements of the European Order for Payment Procedure if the claimant restricts his claim accordingly. But we will talk about this later in about 30 minutes. Then, in contrast to the European Small Claims Procedure, there's no value limit in the scope of application of the European Order for Payment Procedure, so that quantified pecuniary claims can be asserted in the European Order for Payment Procedure, regardless of their amount. The terminology in Article 4, pecuniary claims for a specific amount that have fallen due, is to be interpreted autonomously. So a specific numerical amount must be requested, and this amount must be precisely determinable at the time of filing the form, the claim form. Claims that can also be filed in an unspecified amount according to national law don't fall within the scope of application. And under European Order for Payment Procedure, no orders for payment can be issued for claims that have no fallen due at the time the application of a European Order for Payment is submitted. Yeah, like the European Small Claims Procedure, also the European Order for Payment Procedure does not contain any regulations regarding the currencies, but in Form A, there is the possibility to select all possible currencies of all member states of the European Union. So the assertion of a claim is also possible in a currency other than the euro. Then another requirement is a cross-border case, and in Article 3, paragraph 1 EOPP, you can find a legal definition for that. So a cross-border case is one in which at least one of the parties is domiciled or habitually resident in a member state other than the member state of the court or tribunal seized. We already talked about this this morning, so I will just go quickly through it. So, for example, Article 62 Brussels 1A regulation refers to the domicile for natural persons, and in this context, the court shall apply its internal law. Article 63 Brussels 1A regulation gives an autonomous definition of the domicile for legal persons. So, a legal person is domiciled at the place where it has its statutory seat, central administration, or principal place of business. And the term habitual residence is also not defined in the European Order for Payment Procedure. So according to the Hague Maintenance Convention, it is the center of the person's ties or where the center of his or her existence has been for at least 6 months. Then, according to Article 2, paragraph 3, European Order for Payment Procedure, the term member state shall mean member states with the exception of Denmark. So the geographic scope includes all member states with the exception of Denmark. And in Article 33 European Order for Payment Procedure, you can find rules on the temporal scope of application. So this regulation shall apply from the 12th of December in 2008 with some exceptions. According to Article 6, paragraph 1, for the purposes of applying this regulation, jurisdiction shall be determined in accordance with relevant rules of community law, in particular Regulation number 44/2001. So the European Order for Payment Procedure does not contain its own regulation of jurisdiction, which is why the Brussels 1A regulation is applicable. And it should be noted that Article 6 European Order for Payment Procedure refers only in particular to the Brussels 1A regulation. So it is not excluded that the jurisdiction of a court of a member state results from other union law standards. So Brussels 1A regulation applies only insofar as it's applicable. Yeah, here you can see the jurisdiction system of the Brussels 1A regulation. I will go quickly through it because we have already covered this system this morning. So in Article 4 Brussels 1A regulation, you can find rules on general jurisdiction. This is the domicile of the defendant. The nationality is not relevant, and Article 4 regulates only international jurisdiction. Then in Article 7 to 9 Brussels 1A regulation, you can find rules on special jurisdiction, for example, the place of performance or the place where the harmful event occurred or may occur, and the claimant can choose between general and special jurisdiction. Then you have special rules and jurisdiction in matters relating to insurance, over consumer contracts, and over individual contracts of employment. Then there's the possibility for prorogation of jurisdiction. And in Article 24 Brussels 1A regulation, you can find rules on exclusive jurisdiction, which cannot be overridden by prorogation of jurisdiction and which applies regardless of the domicile and nationality of the parties. However, Article 6, paragraph 2, European Order for Payment Procedure provides an exception to the system of the Brussels 1A regulation regarding consumer cases. So if a claim relates to a contract concluded by a consumer for a purpose which can be regarded as being outside his trade or profession, and if the defendant is the consumer, in this case, only the courts in the member state in which the defendant is domiciled shall have jurisdiction. And the definition of the term domicile is based on Article 62 Brussels 1A regulation. So the court shall apply its internal law in this context. And the habitual residence is not important in this context. So what are the differences between the European Order for Payment Procedure and the Brussels 1A regulation regarding jurisdiction in consumer matters? So we will first take a look on jurisdiction over consumer contracts according to Articles 17 to 19 Brussels 1A regulation. So in order to assume a consumer contract in the sense of Article 17 Brussels 1A regulation, the following requirements must be met. The contract must be concluded by a private and consumer. That means that the contract has to be concluded for a purpose which can be regarded as being outside his trade or profession. And in addition, a consumer case according to Article 17 is only given if it is a contract for the sale of goods on installment credit terms, or it is a third-party finance purchase, or in all other cases, the contract has been concluded with a person who pursues commercial or professional activities in the member state of the consumer's domicile. So this person must actively participate in economic transactions in the consumer's domicile, for example, by providing services locally, or the contract has been concluded with a person who directs such activities to that member state or to several states, including that member state, and the contract falls within the scope of such activities. So, for example, if a person advertises his or her activity from abroad. In this context, the commercial activity does not have to be exclusively directed at the consumer state of domicile, but may also be directed at several member states, and the activity carried out in the consumer's country of domicile must be directed precisely at the conclusion of contracts of the type in question. So one-time or occasional advertising directed to individual persons is not sufficient to fulfill this requirement. So these additional requirements you can see here are not necessary in the scope of application of the European Order for Payment procedure. So the term consumer contract is to be interpreted more extensively in the scope of application of the European Order for Payment procedure. Now we will take a look on Article 18 Process 1A regulation. So if the consumer claims a contracting party according to Article 18, Paragraph 1, Process 1A regulation, he or she can bring proceedings either in the courts of the member state in which the contracting party is domiciled, or in the courts for the place where the consumer is domiciled. And the consumer can also bring proceedings in the courts of the member state in which the contracting party has an establishment. If the contracting party claims the consumer according to Article 18, Paragraph 2, Process 1A regulation, he or she can bring proceedings only in the courts of the member state in which the consumer is domiciled. So the fact that the consumer can only be claimed in his state of domicile correlates with the Process 1A regulation. So if the contracting party claims the consumer according to Article 6, Paragraph 2, European Order for Payment procedure, he or she can bring proceedings only in the courts of that member state in which the consumer is domiciled. Then, according to Article 19, Process 1A regulation, jurisdiction in consumer cases can be departed from with an agreement under certain conditions. And however, in contrast to the Process 1A regulation or Article 19 Process 1A regulation, in the scope of application of the European Order for Payment procedure, agreements on jurisdiction are not possible for claims of the contracting party against the consumer. Then there's no provision in the European Order for Payment procedure for the determination of the territorial and substantial jurisdiction, which is why national law is applicable. In Austria, for example, the District Court for Commercial Matters in Vienna shall have exclusive jurisdiction, and this was intended to make it easier for the foreign claimant who does not have to be represented by a lawyer to lodge the application for a European Order for Payment. The functional jurisdiction is also not regulated in the European Order for Payment procedure, and also in this case, national law is applicable. According to recital 16, the examination of the application does not have to be carried out by a judge. But in Austria, for example, a judge is competent and not the judicial officer, for example. Yeah, how to commence the procedure. So according to Article 7, European Order for Payment procedure, the application for a European Order for Payment is made by using standard form A and lodging it with the court with jurisdiction. And this is intended for the standardization and efficiency of the procedure. So the application shall be submitted in paper form or by any other means of communication, including electronic communication, accepted by the member state of origin and available to the court of origin. And the application shall be signed by the claimant and, if applicable, his representative. The use of the standard form A is obligatory for the claimant, and the form is available in all official languages of the European Union and can be found online. So here you can see again a link for the European Payment Order forms. Yeah, here you can see standard Form A, the application for a European order for payment. So what information is required on the Form A? According to Article 7, Paragraph 2, European order for payment procedure, the names and addresses of the parties and, if applicable, the representatives, the amount of the claim, including the principal, if interest on the claim is demanded, the interest rate and the period of time for which that interest is demanded. Then the cause of action, including a description of the circumstances invoked as the basis of the claim and, if applicable, the interest demanded. Then a description of evidence supporting the claim, the grounds for jurisdiction and the cross-border nature of the case. And this is a definitive list according to the European Court of Justice. So here you can see standard Form A, and the claimant must provide information about the grounds for the court's jurisdiction. So, for example, the place of performance or the place of the harmful event, and also information about the cross-border nature of the case. And in field 6 of Form A, the claimant has to state what the claim relates to, and you have 25 possibilities for that. So, for example, sales contract, rental agreement, contract of service. And in addition, the form contains further details on the circumstances invoked, for example, non-payment, insufficient payment, or late payment. The evidence must only be described but not attached, even if the evidence is a document. And 5 codes are available for this purpose, for example, written evidence, oral evidence, or expert evidence. Then, according to Article 7, Paragraph 3, European Order for Payment Procedure, the claimant shall declare in the application that the information provided is true to the best of his knowledge and belief, and he shall acknowledge that any deliberate false statements could lead to appropriate penalties under the law of the member state of origin. This provision is problematic insofar as in most European countries there are no adequate sanctions for incorrect written statements to the court. So there is also no obligation under European law to introduce sanctions. In the case that the defendant lodges a statement of opposition, the claimant may request in an appendix to the application that the proceedings discontinue, that the proceedings continue in accordance with the rules of the European Small Claims Procedure, if applicable, or that the proceedings continue in accordance with any appropriate national civil procedure. And here you can see Appendix 2 to the application for a European order for payment and the possibilities of the claimant. Then, according to Article 24, European Order for Payment Procedure, the representation by a lawyer or another legal professional is not mandatory in the scope of application of the European Order for Payment Procedure. On the one hand, for the claimant in respect of the application for a European order for payment, and on the other hand, for the defendant in respect of the statement of opposition to a European order for payment. This also applies to an improvement or subsequent restriction of the application. In contrast, the obligation to be represented by a lawyer for the subsequent ordinary proceedings is governed by national law. Then the application shall be submitted in the language or one of the languages of the court, but in contrast to the European Order for Small Claims Procedure, there's no explicit rule regarding the languages. Then, according to Article 8, European Order for Payment Procedure, the court shall examine as soon as possible and on the basis of the application form whether the requirements set out in Articles 2, 3, 4, 6, and 7 are met, and whether the claim appears to be founded. So the court has to examine if the proceedings fall within the scope of application. This is Article 2. If a cross-border case exists, this is Article 3. If a due pecuniary claim is pursued, this is Article 4. If jurisdiction exists, this is Article 6. And if the application meets the requirements in Article 7, and Article 7 regulates the requirements for a correct application. We just talked about this. So the examination of jurisdiction is carried out ex officio and in liminalitis. So what are the consequences if the court is not competent? If the court has no jurisdiction, the application must generally be rejected. Insofar as the jurisdiction is determined by Article 6 European Order for Payment Procedure or and by the Brussels 1A regulation, it is not possible to transfer the case to another court. If, on the other hand, jurisdiction is to be examined but only according to national law, which is mainly the case with territorial jurisdiction and always with substantial jurisdiction, then the legal consequences of an absence of jurisdiction are also governed by national law. The content and the scope of the examination, whether the claim appears to be founded, are subject of controversial debates. And according to what seems to be the prevailing view, all that will be performed with regard to the claim is a plausibility check. So therefore, only a general examination is probably necessary. That means an examination reduced to a minimum on the basis of the application. And according to the clear wording in Article 8, you can see this here, this examination is to be carried out only on the basis of the application form, but facts known to the court can probably also be taken into account. So if the requirements set out in Article 7 are not met, so Article 7 regulates the requirements for a correct application, and if the claim is not clearly unfounded or inadmissible, then the court shall give the claimant the opportunity to complete or to rectify the application. And for this purpose, the court shall use a standard form B. Yeah, here you can see standard form B. And for example, if you use the wrong language, the court will ask you to fill in the correct one. Or if, for example, information about the grounds of jurisdiction or the cross-border nature of the case is missing, then these items must be completed or rectified. Thank you. So in these cases, the court shall specify a time limit, which seems appropriate in the circumstances and which may also be extended. And in principle, this time limit is shorter than 30 days. So what are the requirements for an improvement order? The application is incomplete or information is incorrect. The claim is not clearly unfounded or inadmissible, and it usually takes place before issuing the European Order for Payment. In exceptional cases, also after issuing the European Order for Payment, for example, in the case of an incorrect address for service. So what are the consequences of not improving the application? If despite being requested to do so, the claimant does not approve his application within the time limit specified by the court, then the application shall be rejected. Then there's also the possibility to modify the application. So if the requirements referred to in Article 8 are met only for part of the claim, the court shall inform the claimant to that effect using standard form C. And Article 8 refers to the requirements set out in Articles 2, 3, 4, 6, and 7. So the scope of application, the cross-border case, the requirement of a due pecuniary claim, jurisdiction, and the correct application of a European order for payment. So the claimant shall be invited to accept or to refuse a proposal for a European order for payment for the amount specified by the court. And the claimant shall reply by returning standard form C sent by the court within a time limit of 30 days. Yeah, here you can see standard form C, and the claimant in there is informed about the consequences of an acceptance and a refusal of the court's proposal. So what are the consequences of an acceptance? If the claimant accepts the court's proposal, then the court shall issue a European order for payment for the part of the claim accepted by the claimant. The consequences with respect to the remaining part of the initial claim shall be governed by national law. What are the consequences for a refusal? So if the claimant fails to send his reply within the time limit, or if he refuses the court's proposal, then the court shall reject the application for a European order for payment in its entirety. And there's no right of an appeal against this rejection of the application, but the claimant may file a new application. Then, according to Article 11, Paragraph 1, European Order for Payment Procedure, the court shall reject the application if the requirements set out in Articles 2, 3, 4, 6, and 7 are not met. So, for example, if the application does not concern a cross-border case, or if the court does not have a jurisdiction, or if the claim is clearly unfounded, or the application was not completed or rectified within the time limit specified by the court, or the application was not modified within the time limit specified by the court. And for this purpose, the court shall use standard form D. So it says the court has examined your application for a European order for payment and rejects it on the following grounds. For example, the application does not concern a pecuniary claim or a cross-border case. The rejection of the application in the cases of Article 11, Paragraph 1 is obligatory, and there's no possibility in these cases for a transfer to ordinary procedures. And there's no right of an appeal against this rejection. However, this does not preclude an application for a European order for payment or another procedure available under the law of the member states. So if the requirements referred to in Article 8 are met, so the proceedings fall within the scope of application of the regulation, cross-border case exists, a due pecuniary claim is pursued, jurisdiction exists, and the application meets the requirements referred to in Article 7, so for a correct application, then the court shall issue as soon as possible and normally within 30 days of the lodging of the application a European order for payment using standard form E. This period of 30 days shall not include the time required by the claimant to complete, to rectify or to modify the application. And in the European order for payment, the defendant shall be advised of his options to pay the amount indicated in the order to the claimant, or to oppose the order by lodging a statement of opposition to be sent within 30 days of service of the order to him. Also in the European order for payment, the defendant shall be informed that the order was issued on the basis of the information which was provided by the claimant. So the order was not verified by the court. that the order will become enforceable unless a statement of opposition has been lodged. Where a statement of opposition is lodged, the proceedings shall continue before the competent courts of the member state of origin in accordance with the rules of ordinary civil procedure, unless the claimant has explicitly requested that these proceedings be terminated in this event. So the court shall ensure that the order is served on the defendant in accordance with national law by a method that shall fulfill the minimum standards laid down in Articles 13, 14, and 15. Otherwise, the time limit is not initiated. So we will take a look on Article 13 EOPP, the service with proof of receipt by the defendant, and just like Articles 14 and 15 European Order for Payment Procedure, this article does not contain a directly applicable right of service. It only regulates minimum standards that must be fulfilled according to national law. So the European Order for Payment can be served by one of the following methods, for example, personal service attested by an acknowledgement of receipt, postal service, or service by electronic means, for example, fax or email, attested by an acknowledgement of receipt. Then in Article 14, paragraph 1 EOPP, you can find rules on service without proof of receipt by the defendant, for example, personal service at the defendant's personal address on persons who are living in the same household as the defendant or are employed there, or deposit of the order in the defendant's mailbox or at a post office, or postal service without proof, person to paragraph 3. And then in Article 15, you can find rules on service on a representative. So service according to Article 13 and 14 may also be affected on a defendant's representative. Regarding the language, there's no explicit rule in the European Order for Payment Procedure, but protection is provided by Article 8 of the regulation on the service of documents. So according to Article 8, paragraph 1 of this regulation, the addressee may refuse to accept the document within 1 week if it is not written or translated either in a language which the addressee understands or the official language of the member state addressed, or if there are several official languages in that member state, the official language or one of the official languages of the place where service is to be effected. Then, according to Article 8, paragraph 2 of this regulation, the transmitting agency shall be informed immediately. And then, according to Article 8, paragraph 3 of this regulation, the service of the document can be remedied through the service on the addressee accompanied by a translation into a language provided for in Article 8, paragraph 1. So in a language which the addressee understands or the official language of the member state. Then, according to Article 16, European Order for Payment Procedure, the defendant may lodge a statement of opposition to the European Order for Payment with the Court of Origin using Standard Form F. And this standard form shall be supplied to the defendant together with the European Order for Payment. The statement of opposition shall be sent within 30 days of service of the order on the defendant, and he shall indicate in the statement of opposition that he contests the claim without having to specify the reasons for this. The statement of opposition shall be submitted in paper form or by any other means of communication, including electronic communication, accepted by the member state of origin and available to the court of origin, and it shall be signed by the defendant and, if applicable, his representative. But there's no obligation to be represented by a lawyer when filing a statement of opposition. the statement of opposition is the only available ordinary legal remedy against the European Order for Payment. So apart from this remedy, the European Order for Payment can only be reviewed under Article 20 EUPP. So we will talk about this review later in a few minutes. What are the effects of lodging a statement of opposition? So if a statement of opposition is lodged within 30 days of service of the order, then the proceedings shall continue before the competent courts of the member state of origin, unless the claimant has explicitly requested that the proceedings be terminated in this event. So the statement of opposition leads to the termination of the European Order for Payment procedure and to the initiation of the ordinary proceedings. And the proceedings shall continue in accordance with the rules of the European Small Claims Procedure, if applicable, or any other appropriate national civil procedure. And as already mentioned, the claimant may indicate in an appendix which of these procedures he requests to be applied to his claim in the case that the defendant lodges a statement of opposition against the European Order for Payment. If the claimant has not indicated which of these procedures should be applicable in the case that the statement of opposition is lodged, or if he has requested that the European Small Claims Procedure should apply to a claim that does not fall within the scope of application of the European Small Claims Procedure, then the proceedings shall be transferred to the appropriate national civil procedures unless the claimant has explicitly requested that such transfer not be made. And the claimant shall be informed of whether the defendant has lodged a statement of opposition and of any transfer to civil proceedings, and the transfer to civil proceedings shall be governed by the law of the member states of enforcement. No, of origin, sorry. Now we will come to the enforceability. So if no statement of opposition has been lodged within 30 days of service of the order, the court of origin shall immediately declare the European Order for Payment enforceable using standard form G, and the court shall verify the date of service. So the formal requirements for enforceability shall be governed by the law of the member state of origin, and the court shall send the enforceable European Order for Payment to the claimant. Then, according to Article 19, a European Order for Payment procedure, a European Order for Payment is automatically enforceable in all member states except for Denmark, without the need for a declaration of enforceability in the member state where enforcement is sought, and without any possibility of opposing its recognition. I don't know what this is. Maybe I think we should decline. Yeah. So in principle, enforcement procedures are governed by the law of the member state of enforcement. As in the European Small Claims Procedure, there's also the possibility in the European Order for Payment procedure to request a review in exceptional cases. So after the expiry of 30 days, the defendant shall be entitled to apply for a review of the European Order for Payment before the competent court in the member state of origin. So in which cases is this possible? In case of an incorrect service, if the order for payment was served by one of the methods provided for in Article 14. So Article 14 regulates the service without proof of receipt by the defendant. And the service was not effected in sufficient time to enable the defendant to arrange for his defense without any fault on his part. So this means that he wasn't able to lodge a statement of opposition. And the term service means the actual knowledge of the content of the European Order for Payment. A review is also possible if the defendant was prevented from objecting to the claim by reason of force majeure or due to other extraordinary circumstances, and also in this case without any fault on the defendant's part. So, for example, in the case of natural disasters, this would be force majeure, for example. But fault may also exist, for example, in the case of incorrect office organization or failure to empty the mailbox. And it is unclear if also fault of the defendant's representative justifies to request a review according to Article 20 EUPP. So the wording "without any fault on his part" rather speaks in favor of only taking account the lack of the defendant himself. But according to the European Court of Justice, any fault of the defendant's representative generally does not justify a review. So these two possibilities in Article 20, paragraph 1 European Order for Payment Procedure refer only to circumstances after the European Order for Payment was issued. And in both cases, the defendant must act immediately. So that means within a time limit of 14 days. The purpose here is to give the defendant the chance to defend himself for the first time, and only for special reasons that are not within the sphere of the defendant, he should be given the opportunity to defend himself after the expiry of the time limit. Then a review before the competent court in the member state of origin is also possible if the order for payment was clearly wrongly issued regarding the requirements laid down in the European Order for Payment procedure, or due to other exceptional circumstances. So this refers only to obvious substantial defects. So, for example, false statements in the application because of criminal breaches of an official duty by the competent judge, or an established violation of the European Convention on Human Rights, or grave errors in the application of the law. This possibility offers the defendant an additional legal remedy, and here the defendant could already have defended himself by filing a statement of opposition. So this circumstance justifies that at this level only obvious defects are perceived. And the obviousness of the defect is also the reason that the perception is not bound to any time limit. So how does the procedure take place? According to Article 20 European Order for Payment Procedure, the defendant shall be entitled to apply for a review of the European Order for Payment before the competent court. So the apply for a review must be lodged with the court that issued the European Order for Payment. In Austria, for example, it is the District Court for Commercial Matters in Vienna. And the court responsible for conducting the order for payment is also responsible for the review in accordance with Article 20 European Order for Payment Procedure. Article 20 requires an explicit application by the defendant, so therefore a review ex officio does not take place. The procedure in accordance with Article 20 EUPP is not mentioned in Article 24, so whether there's an obligation to be represented by a lawyer depends on national law. If the requirements in Article 20, paragraph 1 or 2 are not met, the court rejects the defendant's application and the European Order for Payment remains in force. If the court decides that the review is justified, the European Order for Payment shall be null and void. but the European Order for Payment procedure does not contain any further rules on how to proceed after the European Order for Payment has been declared null and void. But according to the prevailing view, in the cases of Article 20, Paragraph 1 European Order for Payment procedure, the transfer to the ordinary procedure shall be initiated. In the cases of Article 20, Paragraph 2 European Order for Payment procedure, the application shall be rejected immediately and no transfer to the ordinary procedure is possible. Then, according to Article 21, European Order for Payment procedure, enforcement procedures shall be governed by the law of the member state of enforcement. So a European Order for Payment, which has become enforceable, shall be enforced under the same conditions as an enforceable decision issued in the member state of enforcement. So this is the equality with domestic titles. What documents are required for enforcement? So the claimant shall provide the competent enforcement authorities of that member state with a copy of the European Order for Payment and, if necessary, a translation of the European Order for Payment into the official language of the member state of enforcement. Then in Article 21, European Order for Payment procedure, you can also find rules about the prohibition of discrimination. So no security, bond, or deposit shall be required of a claimant who in one member state applies for enforcement of a European Order for Payment issued in another member state on the ground that he is a foreign national or that he is not domiciled or resident in the member state of enforcement. Under what requirements can enforcement be refused? So the defendant has the possibility to apply for a refusal of enforcement if the order is incompatible with an earlier decision given in any member state or in a third country. If the earlier decision involved the same cause of action and was between the same parties, and the earlier decision or order fulfills the conditions necessary for its recognition in the member state of enforcement, or the incompatibility could not have been raised as an objection in the court proceedings in the member state of origin. And these requirements must be met cumulatively. Upon application, enforcement shall also be refused if the defendant has paid the amount awarded in the European Order for Payment. And according to Article 22, Paragraph 3, European Order for Payment procedure, under no circumstances may the European Order for Payment be reviewed as to its substance in the member state of enforcement. And as in the European Small Claims procedure, there's also the possibility in the European Order for Payment procedure for the defendant to apply a stay or a limitation of enforcement proceedings. So where the defendant has applied for review, the competent court in the member state of enforcement may limit the enforcement proceedings to protective measures or make enforcement conditional on the provision of such security as it shall determine, or stay the enforcement proceedings under exceptional circumstances. So that's it from my part. Thank you very much for your attention. If there are any questions, please ask. And yeah, thank you very much.
Okay, I would like to thank Eva for a detailed presentation on European Order for Payment. And now I would like to ask all of our participants to pose questions, or maybe someone would like to comment or present their own experience. And in the meantime, while we are expecting your questions, please fill in the feedback questionnaire which is available on the link I have put in the chat. So it is an anonymous questionnaire, and the participants here in the room, they have the questionnaire among their materials. So please fill it in. So regarding today's presentations, for me it is very interesting, something that Eva mentioned, and that was earlier stressed by attorney Dr. Shkov. It is the relationship between jurisdictional rules in the Brussels 1 bis regulation and the European Order for Payment regulation, as well as the small claims procedure. As Eva stressed out, there is only one jurisdictional rule in the European Order for Payment regulation, which is actually different one from the one in the Brussels 1. So this is, I would say, beneficial for the consumer, because it actually defines the consumer contract in a different manner than the one in the Brussels 1 bis, giving them a more comprehensive protection. So when in doubt, a consumer might be more interested in actually starting proceedings pursuant to the provisions of this regulation, since it does not require the consumer contract to fulfill one of the conditions which is actually required under the Brussels 1 bis. And we have a comment. Yes, maybe so everyone can hear what we are discussing. So I'm not sure if everyone agrees.
Yeah, but the problem is the consumer has to be the defendant.
Yes, the consumer has to be the defendant.
Yeah,
That's
so
right.
you can't,
Mhm.
there's and there's the European Payment Order Procedure regulation is stronger than Brussels 1.
Yes.
And sometimes we have difficulties because people say, oh, I have Brussels 1. Why can't I sue someone from Germany? But if you say he's a consumer, you can't.
You cannot. That's right. And also the option of agreeing on a competent court is excluded, as well as the tacit prorogation, which are options under Brussels 1 bis regulation, even for consumer contracts.
Yeah, but we have, for example, if a consumer sues a consumer, then it is possible, because it's not a consumer case.
Yes, no, there is no weaker party, actually. It's a private to private relationship. Yes, so this is something to think about when choosing under which procedure one should start. Okay, if there are no comments or questions, I think we can wrap up for today. So please, if you haven't already filled in the feedback questionnaire, please do so. This is an important information for us, so we can plan our other seminars. Thanks to everyone who has been following this seminar, and we will see each other tomorrow morning. We start at 10. So thank you.
And don't forget your homework.
Yeah, and don't forget your homework. Okay, bye.